This is an unrehearsed program. The views expressed are those of the guests and not necessarily those of the producer. Today's topic:
the new Detainee law in Passion for Truth award-winning program.
Welcome to another edition of Passion for Truth. The new detainee law prepares the ground for possible military trials for Al-Qaeda members. Does the battle against terrorism justify the imposition of unreasonable limits on defendants' rights in the courtroom? All next with our panelists, Benjamin Marsh from Dalit Freedom Network, Tim Ferriss, a news commentator and legal analyst, Holly Jalani, political analyst, also a chair of the Asian Task Force of the United Nations Association Capital Area. As an American citizen, she has been visiting Iraq periodically since the war. Dr. John Waldice, President and Vice Chancellor of Central Buganda University. Dr. Gregory Staunton, President, Genocide Watch, also professor at the Mary Washington University. Welcome you all.
Thank you.
Starting with you, Greg, is the detainee bill a license to abuse, or is it necessary under the present war?
I think it's a license to abuse. And I think the reason it is that by taking up the Hamdan invitation of the Supreme Court, which struck down the previous system of interrogations and so forth, and also struck down deprivation of habeas corpus, it opened the door to Congress to pass laws that would sort of override the Hamdan decision. And in doing so, Congress has passed a law which specifically takes away the right of habeas corpus from prisoners that are currently being held in some of our detention centers, like in Guantanamo, and that also provides them with no legal recourse against people who might conduct illegal forms of interrogation against them. Now, when you take away a remedy, you're essentially allowing impunity. In other words, if you don't allow people to sue for violation of a law or to be punished for violation of a law, you are essentially abolishing the law. And I think that's why this, in fact, is a license to abuse.
You know, that's a crucial point, John. Enemy combatants cannot challenge their detention before a federal judge, and that's exactly what the Supreme Court had said earlier.
Well, I think this whole mess that we're in is a great example of hypocrisy. We are promoting democracy, yet we're taking it away from other people. I don't think there's any way we can promote democracy if we don't practice it. That to me is hypocrisy. These people, no matter what their circumstances, have a right, certain rights to a hearing. It seems for no other reason than logic that you would hear what they have to say. Anybody can be detained, but no one can be detained indefinitely, and that seems to be the way we're going with Guantanamo Bay.
Holly, is President Bush seeking sanctions for torture?
I don't think he's actually seeking sanctions for torture. I think, like all of us, he realizes that he's dealing with some very nasty people, and he simply wants to make sure that they're not given a reason to be let go of. However, having said that, I also feel if we don't give them certain rights under the law, we risk looking just as bad as countries in the third world do when they take people captive and don't give them, don't allow them to appear before a judge and a court and state their own cases. So as terrible as it is and as awful as some of these people are, we have to look a lot better than the laws that are exercised in the third world. We simply cannot afford to go down, or at least be seen as going down to that level.
In fact, we have come a long way since before World War I. We have the 1949 Geneva Conventions. In Common Article 3 of the Geneva Conventions, and let me just read it to you, prohibits cruel, humiliating, and degrading treatment, as well as outrages upon personal dignity. That was the provision that the Supreme Court held was violated, in fact, by the treatment of prisoners at Guantanamo Bay and at a number of other of our interrogation places, like Abu Ghraib. That is in fact beyond the pale. That is international law. That is not something our Constitution or any other law can overrule. And so, in fact, we have to provide safeguards for that. That is what John McCain and others, and John Warner and others, were insisting upon in this new legislation. They think they got it. They think they, in fact, got prohibitions against that sort of cruel and inhuman treatment. The problem is that even though what's written into the law ostensibly prohibits that sort of treatment, there is no remedy for people whose rights have been violated. In other words, if people say, well, you say you kept the law, that you didn't torture me, but in fact you did torture me, the truth is that the current law that's just been passed allows them no remedy, allows them no way they can bring a suit against the people that have tortured them.
If we take the argument that we just heard, not this one, but the other one, we're on a slippery slope. What would happen if we reversed names? In other words, if we said American citizens have been detained in a country elsewhere, wherever it may be, and are receiving that kind of treatment, what would be the outrage of this country? I mean, we would be trying everything possible to stop that kind of action. The torture, the detainee without charges, detention rather without charges, all the things that we are doing, and we say, well, that's all right because they're enemy combatants.
Americans have received that kind of treatment.
That's why John McCain was so upset about this.
Senator McCain himself in the Hanoi Hilton for, what, 5 years or something.
Exactly, and that's why he was so upset about
and
this.
Tortured. But, you know, there's a difference between a person who's wearing a uniform, fighting for a country, and you're at war with that country, and that's a prisoner of war, and some terrorist who's kind of floating around, blowing you up whenever he gets the opportunity. Those are illegal combatants.
Are you aware that John McCain was classified as an illegal combatant, as in fact, an enemy alien, enemy combatant by the Vietnamese, and that is in fact why they did not permit him the rights under the Geneva Convention?
Now, is it, and I address this to Holly, is it a defining moment for the president or for the U.S. that our president goes to Capitol Hill to get sanctions for torture when John McCain and other people have been tortured in the past, and he's well aware of the historical background in Vietnam?
I have to agree with Senators Warner and McCain. These were people who did wear uniform and who know what they're talking about. I come from a background where I have seen people like my father put in jails and tortured, and they had no recourse. So I feel it's very, very important for us to maintain that respect for human dignity, even if it's for a total lowlife like Khalid Sheikh Mohammed. He's a bad man, yes, but he has to have the right to appeal or appear before a judge and state his case. And that is what differentiates the United States from some third world despotic government.
If we run him into one of our courts, say the courtroom down in Alexandria, we're either going to have to let him go and go back to doing what he was doing, or we're going to have to reveal a lot of information that's going to compromise sources and methods.
Not necessarily.
You want to run him through a military hearing, that's one thing. But you run him through an open civilian court, you're going to be making a serious risk to national security.
Sir, I disagree with you there. I'm afraid I've grown up in a military family. I have just come back after 3.5 years of working in Iraq, not periodically visiting Iraq. And the thing for me is that what you call, secret tactics or whatever, they're changing all the time. They're in a state of flux. Mm-hmm. A lot of things the people fighting us know about anyway, and they get to know them almost as soon as we implement